Welcome back to another episode of Spilling Secrets, a podcast on all things related to trade secret and non-compete law. In today's episode, we will be talking about the decision by a district court judge in Texas to set aside the FTC's proposed non-compete ban nationwide and where that leaves employers. My name is Pete Steinmeier. I am the managing shareholder of Epstein Becker Green's Chicago office and co-chair of EBG's Trade Secrets and Non-Compete Subpractice. Today, I'm joined by Eric Weibust, co-chair of EBG's Trade Secrets and Non-Compete Subpractice. Eric, it is always great to do an episode of Spilling Secrets with you.
Good to see you, Pete.
And Eric and I are delighted to be joined today by our partner and friend, Paul DeCamp, who served as the head of the Department of Labor's Wage and Hour Division and who recently won a major victory in the Fifth Circuit, resulting in that court setting aside a tip credit rule issued by the Department of Labor. Paul's an appellate lawyer and a procedural guru, and we are delighted to have him on the show today to talk about some of the procedural ramifications of the Texas District Court decisions to set aside the FTC's non-compete ban.
Thanks for having me. I appreciate it.
Before we get going, let me state that we are recording this on the morning of September 4, 2024, the date the FTC's non-compete ban was initially scheduled to go into effect. A lot has changed since our last podcast on this topic, and with all of the activity in this space, who knows what may happen between now and the date this podcast is actually released. Someday, I hope that some enterprising PhD student tries to calculate the value of the time spent debating this rule, preparing comments on the rule, generally talking and writing about the rule, litigating about this rule, planning for its implementation, and now speculating about what lies ahead. The costs associated with this rule have been staggering. Eric, let me ask you, how much time do you think our team alone has spent on this rule since it was first proposed?
Oh, geez. Considering all of the work we've done in terms of counseling clients, writing an amicus brief, submitting comments to the FTC, writing articles, doing speeches and panels, and responding to economists in the papers, we've easily spent hundreds of hours.
I would bet we could be in the thousands at this point. But with that segue, Eric, can you please start us off by updating us as to where things stand with the 3 lawsuits challenging the FTC's non-compete ban?
Sure. So as our listeners will recall, there are 3 lawsuits filed challenging the FTC rule. The first was filed in Texas. There are actually 2 cases filed there, one by the U.S. Chamber of Commerce and others, and another by a company called Ryan LLC. Those 2 cases were consolidated in the Northern District of Texas. Another case was filed by ATS Tree Service in Pennsylvania in federal court there. And the third was filed by the Villages. They filed that in the Middle District of Florida. The biggest news, of course, came out of the Northern District of Texas, which is the Ryan and U.S. Chamber case, where the court set aside the rule nationally and stated unequivocally that it will not go into effect today. And it did so for 2 reasons. The first was that the FTC does not have authority under Section 6 of the FTC Act to issue substantive rules concerning unfair methods of competition, as opposed to procedural rules regarding that topic. And secondly, that the rule is arbitrary and capricious. And it's the second part of this ruling that was particularly satisfying for us because, of course, we submitted an amicus brief on behalf of 11 national industry organizations arguing just that. We really dug into the studies that the FTC cherry-picked and relied upon. We pointed out studies that they either ignored or gave the back of the hand to. And the court, although it didn't cite our amicus brief, unfortunately, it did come to that conclusion based on many of the arguments that we raised. That court, as you mentioned at the outset, Pete, has actually set aside the rule nationally. In Pennsylvania, at the initial preliminary injunction stage, the court did the exact opposite. The court there, in fact, found that the FTC does have the authority to issue substantive rules concerning unfair methods of competition. And it didn't actually get to any of the other issues that were raised, including arbitrary and capricious. And in the Florida case, the court issued an injunction limited solely to the Villages, the plaintiff in that case, and kind of hedged a little bit, finding that the FTC does have some authority under Rule 6 to issue substantive rules concerning unfair methods of competition. Didn't really get into what the parameters of that were because it found that under the major questions doctrine, which we've written extensively about, particularly since the Supreme Court came down 2 years ago with the West Virginia versus EPA decision, finding that the Congress had not clearly authorized the FTC to issue a rule banning non-competes. So that's where we stand in all three of those cases.
Eric, one of the things that you just said that I'd like to pick up on is that the Texas court set aside the FTC's non-compete ban, but it didn't enjoin it. Now, a few months earlier, that same court had issued a very narrow injunction. Then it later declined to expand it when the U.S. Chamber asked it to do so. Can you please explain the distinction between setting aside the rule and enjoining it nationwide as the court had been asked to do?
Yeah, it's a great question. And it's one a lot of our clients didn't fully understand the difference. And frankly, a lot of folks at other firms were really not focused on the relief that was requested in the Ryan U.S. Chamber case. And that was to set aside or vacate the rule. The injunction stage, as in any case, came at the beginning of the case, and it was asking for injunctive relief pending a final decision on the merits, meaning that you'd have to show a likelihood of success on the merits, irreparable harm, and the other factors that go into that. Once you got past that stage, when we were in the merits stage, both sides filed motions for summary judgment in the Ryan U.S. Chamber case, and the court issued a final ruling on the merits. So at that point, we were beyond the injunction stage, and we were on to the new relief that was being requested, which was to set aside the rule or invalidate it, which necessarily has nationwide effect. And that's what the court did here. It didn't need to address injunctive relief because it was beyond that stage. The other two cases have not gotten beyond that stage yet, but they're currently in the Pennsylvania case. There's a briefing schedule for summary judgment that ends at some point around Thanksgiving. So we won't have a ruling on that for some time. And in the Florida case, the parties have been ordered to submit a status report discussing how they want to proceed, given what happened in Texas and what's going on in Pennsylvania.
Given that the Texas court set aside the rule nationwide, and hence that ruling is going to apply to the plaintiffs in Florida and Pennsylvania as their national employers or employers in the United States, do we know whether the plaintiffs in the Pennsylvania and Florida case are going to continue to prosecute those cases, even though effectively they've gotten the relief that they wanted from the Texas court when it set aside the rule nationwide?
It appears they are, for reasons unknown to me. I've tried to get some diligence, some intel behind the scenes on what their plans are. Nobody's really talking. But again, the Pennsylvania court has now set a briefing schedule that the parties submitted. So it looks like they will be going forward there. And in the Florida case, we'll have to wait and see what happens at the status conference, but there's no indication that the Villages there intends to dismiss the case or request that it be stayed.
Eric, given the ruling in Texas, should employers continue to make preparatory steps to send out the required notices under the FTC rule, or can they safely put pencils down and wait to see what ultimately happens in the courts?
I would recommend that they put pencils down. In fact, I was recommending that even if the Texas court came out with more of a mixed ruling, like it had done at the injunction stage, that there were good faith reasons for not sending out the notices and not, in fact, complying with the order. So certainly now that the rule has been set aside, there's no reason to take any steps to comply with it unless and until something changes at the appellate courts.
I agree 100%. Paul, you just won a huge case in the Fifth Circuit in which you successfully knocked out a Department of Labor tip credit rule. And hence, we wanted to have you on the show just to talk to you about procedurally what is likely to happen in the Fifth Circuit and beyond with respect to the FTC non-compete ban. So let me just start off by asking you, what is likely to happen next in the non-compete ban case in Texas, and what do you anticipate the timetable to be?
The very next thing that has to happen is the FTC needs to decide whether it's going to appeal. I think the operative assumption is that it will appeal. It'll have to make that decision in conjunction with the Solicitor General's office at the Department of Justice. But the next step is if they do decide to proceed with an appeal, they would file a notice of appeal in the Northern District of Texas. They have 60 days to do that from the date of the final judgment. The judgment was entered August 20, the same day that the court issued its opinion in the case. And so they have until October 21, because the 60th day would be a weekend. They have until October 21 to file their notice of appeal. And at that point, if not sooner, we will have a clear indication of whether the FTC intends to really try to fight this out and stand by the rule.
So, Paul, I'm going to ask you the future law school exam question that I'm sure law students are going to be facing in this year and future years to come. Namely, the Texas judge set aside the FTC non-compete ban nationwide and ordered that it not be enforced or otherwise take effect today. What happens if one of the other cases, namely the Pennsylvania case or the Florida case, ends up with a contrary ruling on the merits? Will the Texas decision still have the effect of vacating the rule nationwide?
I believe that the technical term for that would be a real mess. The short answer is yes, the rule is still vacated and set aside nationwide. The Texas District Court has the authority to do that. They did that. And unless that ruling gets overturned, that is the operative rule. At the same time, if another court were to come along and say, on the merits, we think that the rule is fine, it's consistent with the statute and it's lawful, and that decision were to work its way up to an appeals court that would reach a different conclusion from the Fifth Circuit, then maybe at that point you have a case that could be ripe for Supreme Court review. I think in the absence of a circuit split, we would be unlikely to see Supreme Court review, though it could happen. But I think if we were to ultimately see, for example, the Third Circuit and the Fifth Circuit reach different conclusions on the merits of the rule, now we would have a situation that would be more in the wheelhouse for the Supreme Court to take up the issue to resolve that split.
And if the FTC non-compete ban ultimately ends up in the U.S. Supreme Court, how do you see the justices reacting to it, given Loper-Bright, West Virginia versus EPA, and other recent cases discussing the power of the administrative state and how much deference administrative agencies are due?
With the caveat that it is always risky to try to predict how the Supreme Court would address any issue, I do think that the framework that the court would apply is a lot less favorable to the FTC than it might have been 2 or 3 or 4 years ago. I think that there would be much more focus on the threshold questions of whether Congress intended to give the FTC this power and whether what the FTC did actually remained within the boundaries of the authority that Congress gave it. Those threshold issues of, does the FTC have the authority to regulate in this space, I think would be much more important and probably much less favorable to the FTC than under prior jurisprudence. If the FTC were to get past that threshold and get into the phase of the analysis under the APA where we're looking at, was the rule arbitrary and capricious, then it becomes a lot more difficult to predict. But I do think that overall, I would be surprised if the Supreme Court would uphold this regulation on the merits, but that's my prediction, and those are always hard to know exactly what the court's going to do. I don't think that the rule is valid. I don't think the Supreme Court would uphold it, but I'm not on the court.
Maybe you will be someday, Paul. But until that day, all we could do is make predictions, and I happen to share your prediction. Eric, we're at the crystal ball portion of the program. So if you were to gaze into your crystal ball and look out 1 year, 5 years, 10 years, what is the future of traditional non-compete agreements? And what, if anything, should employers be doing now to plan for that future?
So with the FTC's rule now gone, at least for the time being, and assuming it doesn't ever go into effect, we're back primarily to the states governing non-competes, unless Congress can get its act together, and you may see some enforcement actions brought by the FTC, Attorney General, NLRB, or other agencies. But we're back to where we were before, which is with state law governing non-competes. Of course, 46 states permit them in one form or another. The only states that don't are California, North Dakota, Oklahoma, and since last year, Minnesota. But there has been a trend over the past decade or so towards restricting their use and enforcement statutorily or through the common law. A lot of states have enacted or imposed notice requirements, compensation thresholds, and other similar types of protections for employees. Of course, our clients and other companies need to be cognizant of those rules and the changes. There's several proposed changes and enacted changes this year in the states so far. Of course, we have a 50-state non-compete survey. We rolled out a 50-state healthcare supplement to it this year. So folks can go on there and look at the basics and figure out the basic requirements for use and enforcement of non-competes. I don't see non-competes going away, but I do see them to continue being restricted. Perhaps some states will ban them going forward, although we've only seen one state do it in the last 130 or so years. Again, that's Minnesota. But, courts are less likely to enforce non-competes than other types of post-employment restrictive covenants, such as non-solicitation agreements or even garden leave provisions or paid notice periods, confidentiality provisions. Non-competes and non-solicits are only one tool in the toolbox for protecting trade secrets and customer relationships, so companies should focus on protecting their trade secrets using other means as well, whether that means technical protections, updated policies and agreements, doing a trade secret audit, so on and so forth. There's a lot of things that companies can do in addition to or instead of non-competes to protect their trade secrets.
Yeah, I agree with that 100%. A traditional non-compete can be a very effective and powerful tool in an appropriate circumstance, but it's only one tool. There are many other tools, and I would urge employers to look holistically at everything that they're doing and to consider the kinds of things that Eric just mentioned and summarized a minute ago. Okay, well, Eric and Paul, thanks so much for joining today. It's been an interesting discussion.
Thanks for having me.
Thanks, Pete.
And a special thank you to our listeners. As always, if you would like to subscribe to Spilling Secrets, please go to ebglaw.com/subscribe and click the box for Trade Secrets and Non-Competes /Spilling Secrets podcast series. Thanks again, everyone, for joining. Until our next episode, this is Pete Steinmeier signing off on behalf of the Spilling Secrets team.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.